Good morning, all. We have the expert on medico-legal issues, Dr. Tushar Roy, with us. This webinar, which is arranged by IMA South Delhi Branch, is a recurring webinar. This is the 4th episode of the series. Knowledge sharing initiative is brought to you by LycoRed, the cell protector, Metadec injection nandrolone decanoate, and Indocap SR capsules of indomethacin 75 mg in SR form. We have Dr. Chanchal Pal, the president of IMA South Delhi Branch, and the honorary secretary, Dr. G.S. Grewal, with us. Thank you very much all for joining the attendees. And now we hand over to Dr. Chanchal Pal.
Good morning, dear friends and colleagues. Greetings on nice Sunday morning. They say early to bed and early to rise makes a man healthy, wealthy and wise. So at least we will be able to make you wiser, because most of the experts say that doctors who fall in prey to legal hustle or fail to win the cases are not because of their deeds, it's because of documentation. And the most important document here is consent. And we have to learn when to take consent, where to take consent, what time should be taken, from whom to take consent, patient, relative, for all procedures we should take consent, its language, timing, the witnesses and so on. So we have today our expert, Dr. Tushar Roy. Kindly listen to him carefully and apply each word he says to your day-to-day practice to protect yourself from any legal hassles in future. And also, if you want to listen again, you can log into Facebook page of IMA South Delhi Branch or Jagsonpal, and also can share to your friends, because these are very, very important topics. So we want all of you to be not only healthy but safe. That is the motto this year from IMA South Delhi Branch. As for Dr. Tushar Roy, he is our legal expert. Apart from being a senior cardiologist in National Heart Institute of Delhi, I think the oldest institute in Delhi. And also he is DM and cardiology and MRCP for Edinburgh, and he did his LLB in law. So he is as I understand from last 3 webinars we attended, his presentation is crisp and to the point. So kindly listen to it, note down each and every point so that we can learn from him. And we will request him to present something next Sunday also. And it's worthwhile getting up early in the morning and listening to him. So with these words, I all welcome you all on behalf of IMA South Delhi Branch, all the people who are logged in. Dr. Tushar, already 25 attendees are there apart from the panelists today, right now, and I'm sure like last time more will join. With these words, I welcome you, Dr. Tushar, to present your talk.
Thank you, Dr. Chanchal. Always when I start the first talk, I start with the maxim. Can I have the slides, please? And in this case, the maxim is, next slide. Ignorance of the law is no excuse. It's a legal maxim, but it's a very important maxim. And that basically means that in any legal forum, whether it is a local committee or whether it's the medical council or consumer forum or civil court, you cannot stand up and say, sir, I did not know that I had to do this. Sir, I did not know I have to pay income tax. Sir, I did not know I have to write generic name. Sir, I did not know I had to take consent. This is not acceptable in any court of law, because if it was, and even if you genuinely did not know, even then it is not applicable. Because if it was, then everybody would claim it and it would be impossible to run the law. And therefore, the most important maxim in legal practice is ignorance of the law is no excuse. And therefore, what I'm going to say regarding consent, because one of the major problems that the doctors face is that they do not take a proper consent. And therefore, and this is a legal requirement, and therefore, knowing the nuances of when and how to take a consent is most important. Next slide, please. Yeah. So there are various fora in which action or complaint can be brought against us as doctors, and they can be brought against us in all these fora at the same time for the same complaint. That means for the same complaint, they can approach the medical council, the consumer forum, the civil court, as well as the criminal court. And therefore, all four fora can run simultaneously, as has happened in so many cases. The medical council, of course, is there for disciplinary action. They cannot kind of fine us. They can warn us. They can strike our name off the register for a short period of time, long period of time, or even permanently. But they cannot put us in jail. They cannot fine us. Consumer forum is basically for redressal. Something wrong has happened, and therefore they can give you some compensatory. They can ask you to give some compensatory penalty money-wise. Civil court mainly is what we call tort, and I'll talk about it in a little detail about tort, and that is for compensation and damages. And of course, criminal is mainly for punishment, but this is very rare as far as a medical profession is concerned. Next slide, please. So there are various laws that we have to follow. But as far as consent is concerned, the most important law is the Indian Contract Act, way back in 1872. I mean, you'll be wondering why it is called the Indian Contract Act and why not the Contract Act. If the Parliament has made it, I mean, it should be just the Contract Act. Why Indian Contract Act? Because if you see the date, 1872, it was made by the Britishers. And then at that time, the Britishers were making laws for so many other countries. And therefore, they named it the Indian Contract Act. So every single thing that we do regarding the patients is governed by the Indian Contract Act. Of course, other acts also come into play. But one of the most important laws that come into play is the law of tort. Normally, we think that laws are all written down, but you will be surprised to know that many, many laws are not written down. Nowhere will you find it written down. For example, nowhere will you find, for example, civil negligence written anywhere, or civil defamation written anywhere. Or, for example, the tort of battery is not written anywhere. What has happened was that in England, case to case, the judges slowly started developing the law. This law is not written down law, but this law has been developed by what is called the common court or common law by the judges from case to case basis. And this is now actually as strong as the law of the land. So this kind of law, which is judge and case by case decided. For example, the concept of a reasonable man. Nowhere in the law will you write that this is the definition of a reasonable man, but there has been cases in which this has been defined. So this is what the law of torts actually is. But what again concerns us primarily is our ethics regulation 2002, amended from time to time. Normally, you will find that the law is written in pretty complex language. It's very difficult. As I will tell you, when I come to the definition of tort, that's a little difficult language to understand. One does not grasp it immediately. But as far as the ethics regulation is concerned, it's written in very plain day-to-day English, and it is something that concerns us directly. And therefore, I strongly advise you to download it today itself from the National Medical Commission or Medical Council of India site and upgrade it or download it at least once a year and at least read it once a year. Next slide, please. So consent is necessary. And this is a quote that I'm going to say, which was a very famous judge called Benjamin Cardozo. And if you see the date, it's 1914, where this statement was made. That's more than 100 years ago. And what is said more than 100 years ago is valid even today. And I'll go a little bit slowly over this because sometimes we get confused between the various aspects, various medical legal aspects. So what does Benjamin Cardozo say? He says that every human being of adult years and sound mind has a right to determine what shall be done to his body, and a surgeon who performs his operation without his consent, etc., commits an assault for which he is liable in damages. Notice, there is no word which says negligence here. That means even if you're not negligent, even if the outcome is good, but if it has been an adult and of sound mind and you didn't take his consent, then you have committed the tort of assault, actually a battery, and you are liable for damages. So here we are not talking about that you did not make the right decision, you did not do things properly, the outcome was also bad. No, all of it was good. But even after that, if the consent was not properly taken, this is a fault, and you can be held liable for damages. Next slide, please. So this consent requirement follows from our Constitution, Article 21, which is protection of life and personal liberty. And as you know, the Constitution is the mother law which governs all other laws and all other regulations. And Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. And what is the procedure established by law as far as we are concerned, as far as consent is concerned? And that is the Indian Contract Act 1872. Next slide, please. However, in certain cases, although may not be directly or everyday, applicable to us, but in certain cases, consent of the person is not required. For example, a new admission to prison, when there is a court order to examine a person, or when arrest has been made and the police officer who's not below the rank of a sub-inspector comes to you and says that please examine this person, I need an examination report. In that case, consent of the person being examined is not required. Next slide, please. What about consent in an emergency? Yes, it is not required if it is an emergency and life-saving. Here again, I stress the word and. It has to be emergency and life-saving. It is not emergency. It is not life-saving. It is emergency and life-saving. What do I mean by that? For example, a cancer surgery for example, CA breast is life-saving, but you have time to take a consent. Similarly, operation, for example, an appendix or a cholecystectomy, acute cholecystitis is an emergency, but still you have time and therefore consent has to be taken. But in case where immediate intubation is required, where, for example, it's an emergency and life-saving and time to obtain consent is not there, then of course you don't need consent. You have to do what is medically required for you to do. So the essence of the not taking consent is that there is no time to obtain consent. That is, it's an emergency and life-saving. And of course, it has to be done in good faith. And doctors most of the time are doing things in the good faith. And who will decide whether it's an emergency and life-saving? Not most of the people, not all your colleagues, but the law says that it has to be a sizable body of medical opinion, which means that if the case papers are sent to, say, a board constituted by All India Institute of Medical Sciences or Safdarjung Hospital, usually it's a government board, and if they say, yes, this was emergency and this was life-saving and there was no time to ask for consent, then that is good enough. So the decision whether it was an emergency and life-saving has to be taken by a sizable body of medical opinion. Next slide, please. So why is consent required? Of course, consent is required for everything that we do, because everything that we do is governed by the Indian Contract Act, which has an essential component of consent. And consent, a contract needs consent. Parties, this is very important. Parties are said to have consented when they have agreed upon the same thing in the same sense. And this is what is called as consensus ad idem, which is section 13 of the Indian Contract Act. Next slide, please. So what is consensus ad idem? It's important to say that duty is not fully fulfilled just by giving information in the technical manner. For example, I can say, you have an occlusion of the proximal LAD for which you need a DES. I have exactly said everything. Everything is very clear and I have exactly said what is the problem. But the patient has not understood a word of it. If he signs on the basis of such a statement, this consent is not valid because both people have not understood the same thing in the same sense. And therefore, you have to explain what is proximal, what is LAD, what is occluded, what is DES. So all this has to be explained in the terms by which the patient can understand. So duty is not fulfilled by information given in a technical manner. It must be given in a manner that the patient understands this information in general terms. Next slide, please. So what happens if there is no valid consent? Supposing I have not taken a valid consent. So even if there has been no negligence, even if the outcome is good, but there is deficiency of service, and therefore you can be hauled up by the Consumer Protection Act. It is also a tort, and I will, as I said, it's a little bit of complicated definition, but it can also be, for example, under several sections of the Indian Penal Code, which is a criminal offense. Next slide, please. So in tort, for example, as I said, which is a judge-built a compendium of laws, not written anywhere. So it could be for battery. Battery basically means application of force on a person without lawful justification. That means you've touched a person or did something on the person without his consent. This is the tort of battery. Or false imprisonment. You have kept him in hospital without his consent. So this is infliction of bodily restraint, which is not authorized by the law. So the law will only authorize it if the person has consent. Otherwise, you would be liable to battery and false imprisonment as per the tort is concerned. What about the criminal provisions in the next slide? In the Indian Penal Code, 1860, there is sections which say assault, which is punishable for up to 3 months, hurt, punishable up to 1 year, grievous hurt, and there are 6 criteria for grievous hurt, and there are various sections, punishable for up to 7 years, and wrongful confinement, which as you can see, assault is the equivalent of battery, and wrongful confinement is similar to false imprisonment. But these contain jail terms for anything from 3 months going even up to 7 years. Next slide, please. But the Indian Penal Code also gives you some protection. For example, if you look at the last one, 92, section 92, it is not an offense if harm has been caused by an act done without consent, when consent could not be given in time. Exactly what I told you in the previous slide, that if this is an emergency, consent time for consent is not there, you do things in good faith, even without consent, you are protected by section 92 of the Indian Penal Code. What about section 88, 89? Not an offense if harm caused by act with consent done in good faith. You have done thing in good faith, consent has been taken, but harm has outcome because of the act that you have done, you are protected by the Indian Penal Code. On top, section 87, not an offense if harm caused by act done with consent, not intended to cause death or grievous hurt. Naturally, this intention is never there in the case of a doctor. Doctor never intends to cause death or grievous hurt, but you are protected. Next slide, please. So what are the types of consent? So the type of consent could be implied or express. Implied means, for example, the patient comes and sits outside in your OPD. This is an implied consent. This means that he has come to you so that you can question him, so that you can take his blood pressure, so that you can examine him. This is implied. No need to ask him about it. No need to write it anywhere. It is an implied consent. Similarly, an express consent. For example, you are about to administer intramuscular injection, and you tell him, I'm going to give you an intramuscular injection. Okay. And he says, okay, that's an oral consent. That's good enough. That does not have to be documented. But there are certain conditions in which you have to take a written consent. And that is usually in special procedures, which are usually surgical procedure or interventional procedure, even in blood transfusion, for example, or transferring the patient somewhere. Then, of course, written consent is required. Next slide, please. So here are the requirements for an express consent. So when you are taking an express consent, which is usually a written consent, these are the requirements. Number one is from whom should it be taken? And this is the most important thing and the major place where doctors make a mistake. From whom should the consent be taken? Of course, it has to be free. This is usually not a problem with doctors. They are never coercing the patient or anything like that. Usually, the consent is freely given by the patient. It has to be informed consent. Informed, again, is a little bit of a problem. Anyway, what happens if you do not take a consent where consent had to be taken? So even if there is no negligence, one should not confuse it with negligence. Outcome is good, but you have not taken a proper consent. The penalty was 25,000 rupees in 2008, as I will show you in the Samira Kohli case. But currently, the going rate is about 2 lakhs of rupees. So if you have not taken a proper consent, you may be liable to damages of up to 2 lakhs of rupees. Next slide, please. So most important thing is from whom should and this is the most important slide, I think, of this talk. And I'm going to repeat it 3 times. It has to be taken from the patient, from the patient, from the patient. Nobody else but the patient. It cannot be from the relative, from the wife, from the father, nobody. It has to be taken from the patient, provided the patient has capacity to consent, which means that he's an adult and he has got sound mind. So there are only 2 criteria. And if you go back to Benjamin Cardozo, he said adult and sound mind, one more than 100 years ago. And here we have in the Indian Contract Act that you have to take it from the person himself, if the person is a major and if the patient has sound mind. If not, that means if it's not a major or if it's not a sound mind, of course, you can take from the next of kin, and then we'll have to discuss who is the next of kin. Next slide, please. So from whom should it be taken? Again, I repeat myself, if it is a major, that is, it is more than 18 years of age, it has to be taken from the person himself. Any other consent taken from any other person is an invalid consent, provided, of course, that he has got a sound mind. If he's a minor, less than 18 years as per the Indian laws and defined in so many laws, it can be taken from the guardian. And I will also say that the counter signature of the minor is also required in certain cases. Next slide, please. So here's the minor's consent. If it's a minor, then consent has to be taken for the guardian or the next friend. The guardian usually is the parent. I'll tell you about the problems that can occur there, and of course, next friend or somebody else. And there was this case, a Gillick case in 1986 in the House of Lords in the United Kingdom, not applicable to India, where they had even said that, minor below the age of 18 years can also give consent, but it is not applicable in India. So in India, more than 18 years, the person himself has to give consent. Less than 18 years, it is the guardian who has to give consent. Next slide, please. So who is the guardian? So father, mother is usually the guardian in most cases. What happens if the father says yes and the mother says no? Now that's a conflict, and we'll not get into the area because that would be, then we'll not have time for anything else. And if there's a conflict with the minor, for example, if the minor says no and the parents say yes. So you need this procedure, parents say yes, you need this procedure, minor says no. What happens then? So that's again a complicated area. And then how guardian is appointed, again, we will not go there. Next slide, please. So persons usually think that if the person has an unsound mind or has got a psychiatric illness, the patient cannot give consent. This is not true. So insanity or lunacy, for example, psychosis, may constitute an unsound mind, but simple mental illness, depression, for example, or psychosis or neurosis or say depression, for example, delusional neurosis may not constitute an unsound mind, and there are judgments on that. So not all mental illnesses are of unsound mind. This has to be kept in mind. And what they use is a functional test. What is the functional test? The functional test is, can the person understand the information that is being given to him? Can the patient form an informed decision based on that information? Can he then convey that consent to the doctor? If he can fulfill these three criteria, then the patient is not of unsound mind, even though at certain times he may be having delusions or neurosis, for example. Sedation, unconsciousness, of course, constitutes an unsound mind. One cannot give a full consent under sedation or, of course, unconsciousness. There are other medical conditions, for example, severe hyponatremia, for example. A sodium of, say, 125, the patient has unsound mind, cannot give temporarily is of unsound mind and cannot give consent under those circumstances. And, of course, not otherwise fit. So then consent has to be taken from the next of kin or the guardian or the legal representative or the next friend. And the most important thing is that when you ask the relatives, because the person cannot give, the person is on a ventilator, for example, you ask the relative, you ask the son, you ask the daughter, what should we do? Should we do X procedure or Y procedure? What we are asking is not the opinion of the son or the daughter. This is important. We are not asking what his son and daughter wants. We are asking what would the patient have said if we had asked the patient, because you are closest to them, so you would know how the patient would have responded. So we are asking you to respond what the patient would have said if you had asked him. We are not asking your opinion. This is a very important distinguishing feature. So we are asking how the patient would have responded and not the opinion of the son or the daughter. Next slide, please. Of course, consent has to be freely given. That means there must not be any coercion, any undue influence, fraud, misrepresentation, or mistake. Of course, this goes as far as the contract is concerned. But for us, normally consent is freely given. And for us, the only little bit that might come into play is undue influence, because doctors are considered to be persons in authority. So they may have an authoritarian figure, especially what is the head of the department, etc. And that may influence or unduly influence the action or the decision of the person giving the consent. And therefore, undue influence should not be borne to bear in cases of consent. Otherwise, the consent may be invalidated as not being given freely. Next slide, please. So there is another complicated area, which is the informed consent. Now, it's a little bit of a dicey. So there is a list of 6 cases which has been noted down not by me, but by the Supreme Court. Now, Supreme Court, in the 2008 judgment in the Samira Kohli case, where they put down what should be the contents of a consent. And normally, Supreme Court judges, they sit in pairs. So in the High Court, they sit as one judge, and then division benches of 2 judges, etc. But in the Supreme Court, they always sit in pairs. And whenever there is a question of substantial legal importance, then 3 judges sit. And this was a case where 3 judges made this decision. Just to put things in perspective, there is only one case, one medico-legal case, that is the case where they gave the advanced medical directive, where 5 judges made a decision in the Supreme Court, and there are 7 cases in the last 70 years of the Supreme Court. 7 cases only where 3 judges have made a decision, and this is one of the 7 cases in which 3 judges have made this decision. And what you have to put in the informed consent, why is the procedure required? How the procedure will be done in general terms so that the patient can understand who will do the procedure or who all will do the procedure. What is the benefits of doing the procedures and consequences of not doing the procedure? And what are the material risks involved? And we'll go into a little bit detail because that's where the informed part of the consent comes. And what are the alternative therapies that you can do, and what are the risks and benefits? For example, you can do medical therapy, although I'm recommending angioplasty, but you can do medical therapy, and these are the pros and cons of doing the medical therapy vis-a-vis or you can do a normal CT angiography or a CT angiography versus a normal angiography, and these are the pros and the cons. So alternatives have also to be discussed. So let's go over the 6 again. Why the procedure is needed, how the procedure will be done, who will be doing the procedure, what are the benefits of doing the procedure and consequences of not doing the procedure, all the material risks, and of course, alternative therapies. And this was by a 3-judge decision in the Samira Kohli case, 2008. Next slide, please. So a physician who violates his duty to his patient and subjects himself to liability if he withholds any facts which is necessary for him to form the basis of an intelligent consent by the patient. So what he says is that basically, if you do not do this, if you do not give all the information required, or if you do not answer the questions of the patient to the degree that is required, then you can be held liable. Next slide, please. So this is the famous Samira Kohli case, and I'll be going a little bit in detail. See how interesting it is. This was a 44-year-old unmarried lady who was admitted under Dr. Prabha Manchanda in 1995 with menstrual problems. Of course, they took a consent for diagnostic and operative laparoscopy, may need laparotomy. Of course, the patient required laparotomy, and at laparotomy they found that there was extensive endometriosis, and the proper medical thing was to do a hysterectomy with bilateral oophorectomy. So, of course, the patient was under general anesthesia. So, Dr. Manchanda sent an assistant outside, and the mother was outside, and they took the full consent of the mother. They explained it to the mother. This is the way out, and the mother said, "Yes, yes, go ahead." The mother signed the consent, and they took the consent for hysterectomy. But what was actually done was abdominal hysterectomy with bilateral salpingo oophorectomy. Now, when the patient came to know about this, the patient raised a hue and cry. Next slide, please. And there was this case which was filed by the patient against the doctors, and then the doctors also filed against the patient because of non-payment of hospital fees and so on. And ultimately, after 13 years, from 1995 for 13 years, this case went on, and the Supreme Court, three judges said this: number one, that there was no negligence, that the decision was correct, the procedure was done correctly, outcome was good, there was no negligence whatsoever. However, the consent was not valid. For example, this was neither an emergency, nor was it life-saving. And therefore, the question of it being an emergency and life-saving was not there. And therefore, this is a case of battery. And they awarded 25,000, as I said, 25,000 and 10% interest in that particular case. So please understand this case. Everything was done properly, but the patient, the consent was taken from the mother when the patient was an adult and of sound mind, and it was not a case of emergency and life-saving nature, and therefore this resulted in a tort of battery, for which 25,000 was awarded to the patient, and now the current going rate is 2 lakhs of rupees. Next slide, please. So types of informed consent, various types, and this essentially in India we are following what is called the valid consent. For example, the standard is that of a reasonable doctor. What that means is that what would a reasonable doctor tell his patients? So that is the standard. How much should you tell? Should you tell that 0.0001% risk that may occur? No. The Supreme Court of India is very clear on that point, that whatever a reasonable doctor usually would tell the patient, if you tell that to the patient, then that's enough. But there are hierarchies. For example, in the UK, they have now changed over from a reasonable doctor to a reasonable patient. For example, what would a reasonable patient expect from the doctor? What is the information that a reasonable patient would expect from the doctor? That is the standard that is followed in the UK. And even higher standard is followed in Canada and Australia. That is, what would this patient have expected from the doctor? For example, if the patient is of a higher intellectual capacity, for example, that patient may be wanting more information. So then what is this patient wanting? So there are 3 categories. What would a reasonable doctor tell a patient? What would a reasonable patient want from the doctor, what kind of information, and what would this patient expect from the doctor. So there are these three various levels of informed consent. As far as we are concerned in India, it is still, we follow the Bolam's rule, and I'll be talking about that. So what basically means is that what would a reasonable doctor, or what do usually the doctors or a reasonable doctor would tell his patient? Next slide. So the valid consent or real consent is the amount of information that a reasonable doctor would provide. That's in our case. UK, of course, as I said, has gone to the reasonable patient test. Next slide, please. So real consent is what a reasonable patient would need. That is a patient level. Next slide, please. Yeah. So a risk is material when a reasonable person is likely to attach significance to the risk in deciding whether or not to forego the proposed therapy. That means, again, this is the reasonable patient standard. What would the reasonable patient expect, the kind of information that he would expect from the patient? Next slide, please. However, as I said, in Australia and Canada, they follow even higher consent. What would this patient have expected from the patient? So that's a very high level, not followed in India. Next slide, please. So as I said, the consent in India is as a reasonable body of doctors would normally inform the patient, and that follows what we call the Bolam rule. And we'll talk about it when we talk about cases of negligence, maybe in the future. So adequate information is what is required, but there is no need to discuss remote or theoretical risks. So that is the standard that we follow in India. Next slide, please. So now the special types of consent, for example, the AMD, the Advanced Medical Directive, that is the DNR or that kind of a form which the patient gives in advance, an advanced medical directive, which was by, as I said, 5 judges decided in 2018, Common Cause versus Union of India. It's a little complicated case, but there again, the consent of the person is not required because he has already given an advanced medical directive. Next slide, please. So here are the special cases. So there is nothing called a blanket consent. For example, you can't expect a patient to write on admission that I agree to all the procedures that will be done to me during my hospital stay. And that's absolutely not valid. So blanket consent is not valid. Of course, as I said, advanced medical directive is now applicable in India after the 2018 directive. That is a DNR and so on. Don't put me on a ventilator, things like that. But it's a little complicated, and the procedure is also pretty complicated. Special cases are loco parentis, for example. For example, the group of children has gone to a picnic and the teacher is accompanying them and some mishap happens to a student. Then it is the teacher who is the local parent, a loco parentis. The teacher can take a decision of what is to be done. Maybe stitching is required, tetanus is required. But the teacher is the one to take the decision in that particular case. What about an unknown person of unsound mind brought to the hospital? Who will take the decision? The decision of consent must be taken by the doctor in charge of the hospital. So an unknown person, unsound mind, who will take a decision that surgery is required or ventilation is required? It is the doctor in charge of the hospital, usually the medical superintendent. What if the patient is not conversant with English, for example? Because nowadays forms are written in English, and the patient may, and they have said that I didn't understand a word of what was written. The doctor said sign here, and I signed there. So additional consent, if it is possible, of a close relative who knows English, and preferably by a couple of witnesses who are not members of the hospital staff. Another very interesting way of avoiding this problem is to keep a small gap between your written material and the signature. A small gap between the written material and the signature, where the patient can write in his or her own hand, in his or her own language. And the content could be that the above has been explained to me and I agree. Very simple. The above has been explained to me and I agree. If this is written in the person's own handwriting, in the person's own language, and then they sign, then of course they can't then go back and say that I have not understood what has been said, and the doctor thus said that, and so therefore I just signed. Next slide, please. So exceptions to full information is when you feel that by explaining or saying everything to the patient will cause severe psychological harm to the patient or affect his recovery by affecting him psychologically, then full information need not be given to the patient. And this is called the therapeutic privilege, and explained in this particular case, therapeutic privilege. But as things are going now, it is preferable that you do not invoke the therapeutic privilege and that you tell the patient generally everything. At least you tell the relatives everything that is going on, so that you are not blamed later on of not saying, not giving the full information. Next slide, please. So what is the consent procedure? This is very important. So we've talked about who should the consent be from, what should be the ingredients of the consent, and this is the procedure. Counseling must be done by the doctor who will carry out the procedure. So it is the senior most doctor who has to counsel the patient. For example, it is the cardiothoracic surgeon who has to explain, say, going for a mitral valve replacement surgery, what are the risks of surgery, what is likely to happen, how many days of therapy, etc., etc. So actual consent may be taken by an assistant or a nurse, but the counseling has to be done by the doctor in charge. This is often not done. And if it is not done, again, it results in an invalid consent, and therefore your consent may not be valid. So if there's multiple pages, then initials on all the pages, and signed in full and dated in the last page. And as I said, if you keep a gap and they write in their own language, in their own hand, in their own handwriting, that the above has been explained to me and I agree, then that goes a long way. Usually it has to be in the same sitting using the same pen. If there are differences in the pen, then again courts have, and these cases have been there, courts then say that this has been done before, this has been done afterwards. So it has to be done with the same pen. And if there are any cutouts, usually there should not be any cutouts, but if there are any alterations, then a single line should be drawn to that, and then whatever has to be correction has to be made on top of that. So signature of a minor, in case of minor less than 18 years of age, signature of minor, maybe above 12 years of age, also required. Not for any consent purposes. As I said, the consent is given by the guardian, but for assent purposes. It's called assent. Therefore, the minor is also assenting to the procedure. The West Bengal board has said that it must be countersigned by the doctor. No witnesses are usually required. However, if you are explaining things, if the consent is written in English and you are explaining things to him, for example, in Hindi or Bengali or Punjabi, then it is better to get a witness to countersign that, and the witness preferably should not be from the hospital. Next slide, please. So once the consent has been taken, there must not be any deviation or variation from the procedure. So it's interesting and important to write multiple things. For example, you can say that Dr. Roy, Dr. Pal, Dr. Grewal will be doing the surgery. And if he signs to that, that's fair enough. Then Dr. Roy or Dr. Pal or Dr. Grewal can do the procedure. No problem. But if you write only Dr. Roy, and then subsequently Dr. Pal does the surgery, then that is not a valid consent. Also, if you write a particular surgery and you do a slightly different surgery, then that also may invalidate the consent. So therefore, make it broad, make it multiple people may do the surgery, make it that we may do this kind of procedure or that kind of procedure depending on the case as it turns out as I'm doing the procedure. But once the consent has been taken, there can be no variation or deviation from the procedure. No additional procedures can be done, which was the problem in Samira Kohli case. I mean, the doctor in full good faith thought this patient is under general anesthesia. I mean, it doesn't make sense to wake the patient up, then ask the patient, then again give GA, and then again do the procedure. It doesn't make sense. I mean, everybody agrees that that total abdominal hysterectomy with the salpingo-oophorectomy was what is required. But then the Supreme Court says, no, this was not emergency, this was not life-saving, and therefore waking the patient up from the general anesthesia, asking the patient for the consent, and then going back and doing the procedure was the proper thing to do. And as I said, that the Supreme Court is the final arbiter of the laws of a country. And of course, there can be no change in the treating doctor. And as I said, so you can put oblique, Roy, Dr. Roy, oblique, Dr. Pal, Dr. Grewal, and so on. Next slide, please. Special problems. What happens if during the procedure, the patient withdraws the consent? You're doing a CAT procedure and halfway through he says, I don't want to. Now, of course, in that case, the courts are very clear. The final decision is of the physician, depending on the case. For example, if you're far advanced into the procedure so that withdrawing will harm the patient, you carry on with the procedure, do not agree with what the patient has said. But if you can withdraw, you've just done the puncture, but you're not, this thing, then of course you have to withdraw if the patient says, I don't want this. Next slide, please. So consent is also required for transfer from the hospital, either with a discharge on risk or consent for transfer. Blood transfusion requires separate consent, and of course clinical trials, which is a big trial, a big subject in itself. Consent for clinical trials is a big subject in itself. That also, of course, requires consent. Next slide, please. Of course, as I said, no additional procedure once the consent has been taken, unless, of course, it is life-saving and an emergency. For example, During a cesarean section, the doctors found a large fibroid which was likely to affect the future pregnancy, and so they went ahead and did sterilization, right? They did it in good faith. They did it to protect further pregnancies, further risk of pregnancy of the patient, but it was not a proper consent. And again, this doctor is liable to the tort of battery. Next slide, please. So what is the validity of the consent? So how long before should the consent be taken, and how long is the given consent valid? There's no exact rule as to till where it is valid, but it is prudent to take it as close to the procedure as possible. Don't rely on a consent that has been given 2 days ago to do a procedure that is 2 days afterwards. Get a consent as close to the procedure as possible. Next slide, please. So here are the important points. So always take a consent, make it broad. There's no harm in making it broad. That so and so doctor can be doing. We may do this also, but if there's a problem, we may do that also. So make it as broad as possible, because if you narrow it down, then you cannot go beyond that. But if it is broad enough and the patient has agreed to that, then you can do whatever they have agreed to. Again, the most important thing is that it has to be from the patient only. The word is patient, and the patient is only. The wife, the husband, the father does not matter. Others may countersign. If the patient is an adult, informed consent. As I said, in India, the rule is the Bolam rule. That is what a reasonable doctor would tell the patient is the rule that we follow. We do not follow any of the higher rules, as I have discussed. As close to the procedure as possible. So the consent should be taken as close to the procedure as possible. And I've discussed the method of taking the consent. That means the counseling has to be done by the doctor. The actual procedure can be done by the nurse or by the junior doctor, but the actual counseling has to be done by the doctor who's going to do the procedure. And stick to the consent, and don't do any additional procedure without taking an additional consent. Next slide, please. And thank you very much for your kind listening.
Thank you, Dr. Tushar.
Thank you, Dr. Tushar. It was a very absorbing presentation. My first interaction, first of all, we welcome His Excellency Dr. Prema Grewal to our webinar. So, Dr. Tushar, a lot of people here are single doctor clinics having their own practice. A patient comes into my clinic and says, I have fever. Does the requirement of a consent happen here, or is there a concept that the person has come on his own, therefore does not require a consent?
Exactly. So this is what is called as an implied consent. Simply that the patient has walked into your office is implied that you can take his blood pressure, you can do, you can examine him, you can give him prescription. So you don't need any kind of consent. It is an implied. Simply the act that the patient has come to your clinic is implied. So no other consent is required. Except if you want to, for example, give an intramuscular injection, then an oral consent would be required. So you tell the patient, I'm going to give an injection. It's okay. If he says yes, then that's good enough. Nothing written needs to be documented.
What about OPD procedure, Dr. Tushar? Let me put a comment that you have had a wonderful session as usual.
Thank you.
And OPD procedure, sometimes we have to do incision drainage or maybe a suture removal.
Right. Suture removal and incision drainage definitely will require a written consent. Suture removal, I'm not sure. Maybe an oral consent would be okay. But an internal examination, for example, a finger examination or the instrumental internal examination, that does not require any formal consent. That is implied. So internal examination is implied. Suture removal and oral may be enough, but incision and drainage would definitely require a written consent.
Okay. So there are few points I would like to ask before we put, there must be very many questions, though you were so elaborate, but definitely the topic is such that we always need to clear, because this will, don't want to land in legal hassle. Number one was that there was, when you said change of pen, because usually nurse or the resident take the consent, but by the time you come to countersign, usually that particular person has gone, like especially resident has gone to another ward or to the OT, and you are countersigning with your pen. So they are definitely you are asking the patient. Yeah.
No. Your pen could be different. There's no. You don't have to sign with the same pen that the patient. But when the patient signs, for example, or patient has write something, then that writing and that pen of the patient has to be the same. The patient's pen need not vary. Should not vary.
Another thing that sometimes we, as you said, oblique procedures.
Yeah,
Sometimes
yeah.
we mention multiple procedures, say nose we have to do turbinectomy, this and that, and sometimes we don't need to do. We go inside
Yeah.
and that we don't need to do it. So how do we fall? Because there's, you say we should not do additional procedure, but sometimes we feel ki
Yeah.
it's required. So what
No.
is the law says?
No, doing less procedure is not a problem. Because if you go there and you find that something is not required, and then you come back and say, no, I went in and I found that this was not required, then that's perfectly all right. The problem is doing the additional procedure without doing the consent. That is a problem. Not doing the procedure, coming out and then explaining why you did not do the procedure is perfectly all right.
Okay. And when you said there was little confusion about the minor signing, it's optional or you should always ask the minor, because sometimes the children don't want to get anything done, you know.
Yeah, yeah.
So,
So this is in India. This is optional actually. So assent of the except in for example in clinical trials, but in the day-to-day practice, the signature of the minor is optional. It's the signature of the guardian. The problem occurs actually when the father says yes and the mother says no, or the vice versa. Then that is a huge problem. So we are not sure exactly how to deal with that problem if one says no. Similarly, we have faced problems when there are say two sons and a daughter, and they do not agree amongst themselves what is the final outcome, and then the doctor is there holding the patient. They don't know what to do because the daughter says go ahead and the son says don't go ahead, and then you have a problem. So these are unresolved problems, no judgments on this point, and therefore we don't know exactly how to proceed under those circumstances.
okay. Another thing that you usually there are certain usually pre-printed consents, and
Yeah.
in this JCI and other things had come in, and when they started saying that each procedure should have a different consent.
Yeah,
So,
yeah.
so what does the law say? Because very difficult to print for the hospital also, or should that be handwritten? I don't know, like how to solve that particular problem.
No, because nowadays you see there are these computers, so you can have variations on the computer and give a printout. So I don't see why it should be press printed. There is no need for a press printed, because press printed a standard information consent actually doesn't go very well with the courts. They say that ये तो standard है, ये तो this is not. They are not very happy with that. But now with the advent of a computer, you can have variations. You can have variations for angiography, for example, or angioplasty, or stenting, or a pacemaker. You can have different thing, and it just requires a printout from the computer. So that should not be too difficult to pass. So separate consent for separate procedure is a better idea.
Okay, because then in hospitals, practically, since you're also working,
Yeah.
it's difficult for hospital to get things printed for each and every patient. So usually it is a printed, to tell you very frankly, it is a press printed consent where we get and the resident gets it signed. So,
For example, if something is totally different, then of course you need a totally different the consent form. But supposing let's say, for example, angiography without stenting, for example, then you can have the same, and you can cut out the parts which you don't do. For example, it's only for angiography, you cut out the parts regarding the stenting. If it's for angiography and stenting, then keep all of it together. So those kind of minor variations are there. But supposing it's an angiography, and supposing it's a pacemaker, so there are two entirely different. I think there should be two entirely different consent forms.
Dr. Tushar.
Yes, sir.
for a department, you should have one consent for each department, like say. That is what.
Yes.
Okay. With that, I think thanks a lot, and I hand over the mic to Dr. J.S. Grewal to carry out the procedures.
Thank you. Dr. Tushar, yeah, we have Dr. Padal, Dr. Prem Agrawal, and Dr. Vinod Raina who are waiting to ask. So His Excellency gets preference. So yes, Prem.
It is always a pleasure to. In fact, since my student days, I always wanted to listen from him on and on, and it was a treatise on consent. In fact, nothing less than that. I'd like to make few comments. One is the implied consent. Today, the implied consent is quite misused, and I had a recent very serious case where the gynecologist had written the abortifacients, and patient bled, and it was MTP. And then the gynecologist said that I've just written a medicine. It is implied consent that she came to me, and we had a lot of difficulty. And the doctor was punished for doing MTP without a consent. And that consent is also very special. because it is taken in a particular form of 2C and has to be done in a special procedure. We are doing MTP. So if you are writing a medicine and that is leading to a sort of a procedure, it will not be implied consent. You require a separate consent altogether. Number two is a issue which is informed consent. I would like to very clarify that informed consent means three things: risk, benefits, and alternatives. That Supreme Court judgment is very clear about it, that risk, benefits, and alternatives. And that risk, benefit, and alternatives are different for each procedure. This resistance of Dr. Chanchal Paul that the hospital gets printed is false and not standing today. And a doctor not taking consent, informing the risk procedures, risk of the procedure, benefit of the procedure, and the availability alternative, which has to be separate for every procedure. And suppose I do angioplasty, a high-risk angioplasty, without telling them that there is a bypass procedure also available, and which is thought to be good in these aspects and which is not thought to be good in these aspects. And then we take a consent of the patient that, yes, and I want to go for high-risk angioplasty. So that is an issue which can be summarized into only 3 points: risk, benefit, and alternatives. Okay. If you have identified the risk of that particular procedure, and which can be little elaborate, and benefit of the procedure which can be there, and the alternatives which are available, and again the risk benefits of the alternatives also. This is important. If you concentrate on this point only, then there cannot be any generalized consent, any printed consent, and that consent has to be patient specific. That consent has to be person specific, and situation specific, and the procedure specific. So the resistance of the doctors that they should get a prepared consent and get it signed by the resident will get it signed, I think will not stand in the today's context and future. And the only other thing which I would like to say, that this particular lecture, which is Dr. Tushar has prepared with so much difficulty, I understand that how much effort he would have done would need more audience than what is available here. I think this should be recorded and should be disseminated to a large number of people, so that this is a benefit to everybody. What he has spoken today is a need of art that everybody should know. Then how to disseminate it, I think Bobby is very effective in doing all this. And I wish that Dr. Tushar, congratulations, Dr. Tushar, once
Thank
again.
You, sir. Thank you, sir.
Thank you, Excellency. Yes, Dr. Podar, please go ahead.
So thank you, Dr. Grewal, sir. Actually, I'm traveling, so I will keep my video off. The internet connection is not very good. So the point raised by Dr. Chanchal Pal, then subsequently also discussed by Dr. Prem, the point of the printed consent form, the judgment was given by Justice Dr. Kartikeya in RG Stone case. And I spoke to Justice Kartikeya one-to-one on length on this point. He said, by printed form, I meant that for this every procedure, you can't have the same printing form. Like in a hospital where most of the cases are cardiology, you can have a consent for cardiology cases. For laparoscopic cholecystectomy, you can have a printed form, which can be used in all the patients. Because the complications in laparoscopic cholecystectomy will be same in all the patients. You can write on in printed form that complication can be bile leakage, bleeding, or like that. So it has to be specific to that procedure, then you can have printed form. This was Dr. Justice Kartikeya's opinion. And one question to Dr. Tushar. You said that if two surgeons are operating, the both surgeons' name should be there. If both surgeons are from the same specialty, still both surgeons' names should be given, or if they are from different specialty, like if surgeon and gynecologist are operating, then we always give two names. But if two surgeons are from the same specialty, one is assisting, then usually we don't give two names. Is it okay?
Yeah, this is absolutely okay. I was not talking about the assistant. I was talking, supposing, it's Dr. Podar and, Dr. Prem Agarwal, they are going to operate. And for some reason, Dr. Prem Agarwal is not there and Dr. Podar operates. Then if you don't have the two names from before, then Dr. Podar cannot operate. Then you need a different consent. So it's the primary operator name which is the alternative. For example, if Dr. Podar is present, he will operate, or if Dr. Prem Agarwal is present, then Dr. Prem Agarwal will operate. So either or, if it is like that, then it's okay. And of course, if there are multiple from say neurology operating with the orthopedic surgeons, then both names are.
Both names.
Yeah.
Dr. Vinod Raina, please. Welcome. You're kindly unmute yourself. Kindly unmute yourself. खाना बंद करके फिर सवाल पूछिए.
Sir, thank you, Dr. Bobby Grewal, and thank you, South Delhi Branch, to organize such a great event. And thank you, Dr. Paul. My question is, sir, I am a standalone clinic doctor. I am treating HIV, and I have sometimes very serious patients. And I definitely take consents from the patients whenever they come to me, because there are guidelines by the NACO that I had to take the consent from the patient. Usually we take a simple consent, but few years before, there were some problems with the consents. Whenever the patients used to come to us, तो वो बहुत बार हमको बोलते थे कि सर आपने हमको जो बताया, हमको तो इंग्लिश आती नहीं, आपने साइन करवाया तो हमको पता नहीं है कि आपने क्या लिखवाया और क्या कराया. तो सर अब मैंने एक इलेक्ट्रॉनिक मेडिकल रिकॉर्ड, एक सॉफ्टवेयर खुद बनाया है. तो मेरे पास कोई भी पेशेंट जब आता है तो ऑटोमेटिकली हर एक पेशेंट की मैं रिकॉर्डिंग रखता हूँ. ये ऑडियो में भी है और वीडियो में भी है. जो ही मेरे पास पेशेंट बैठता है तो मैं इसका एक फॉर्मेट बनाता हूँ, उसको सेव करके रखता हूँ. तो आगे जाके मान के चले अगर कुछ परेशानी होती है तो वो रिकॉर्ड मेरे काम आता है. और दूसरा, जब भी मेरे को लगता है कि ये पेशेंट सीरियस है या मेरे को इसको कहीं रेफर करना है या मेरे को कुछ दवाई में चेंज करना है, तो मैं उसकी वीडियो कंसेंट लेता हूँ. तो उस वीडियो कंसेंट में उसको पूछता हूँ कि भाई आपको हम ये ट्रीटमेंट स्टार्ट कर रहे हैं और इसमें हम दवाइयों का चेंज कर रहे हैं क्योंकि आपको पहले से प्रॉब्लम है, CD4 कम हो रहा है, आपका वायरल लोड ज्यादा है, और दवाई स्टार्ट करने से आपका वायरल लोड बढ़ भी सकता है, CD4 कम भी हो सकता है, आपको प्रॉब्लम्स हो सकती हैं. क्या आप अनुमति देते हैं? अगर वो बोलेगा हाँ सर हम आपको अनुमति देते हैं, तो सर मैं प्रोसीजर स्टार्ट करता हूँ, मैं उनको ट्रीटमेंट देता हूँ. सर मेरे को ये खाली पूछना है, क्या ये मैं सही कर रहा हूँ, क्या ये लीगली वैलिड है?
बिल्कुल, this is legally valid. The only problem is that sometimes it can be used against you. For example, as Dr. Prem Agarwal said, and also I mentioned, that there are those 6 points that are there. So if you have not covered any of those 6 points, then a clever lawyer, because he's also got the recording, so a clever lawyer can use it against you and say that although you have taken these points, but these 2 points were missed, and therefore it's not a valid consent. So it can play.
Dr. Tushar,
can play in, yeah.
How, if I say that, even Dr. There is a questioner, Dr. Neeta, what is the legal validity of an oral consent? मैंने पूछ लिया था.
हाँ, नहीं, it's valid. It's valid. Oral consent is absolutely valid. The only problem is that if there's a dispute, how do you prove that you have taken an oral consent? So that is what Dr. Raina is saying, that I prove that I've taken an oral consent by recording, by keeping a record of it either as an audio or as an audio visual. So I'm saying that's perfectly all right. It's perfectly valid because now things can be validated. Yeah, if there's a video recording, it can be validated whether it has been doctored or not doctored. There are experts who can do that. So if it's not doctored, it's a valid legal document. The whole problem is that there are 6 points of the consent, and if you've missed any one of them, then that can be used against you. That आपने तो ये पूछा, but आपने ये नहीं पूछा, and therefore the whole consent is invalid. So it can be a double-edged sword. So it can be worked against you. I think a better way would be if they can email you or WhatsApp you their written consent, and you can keep a copy of that. That might be a better option, because now with this Gmail you can keep it indefinitely. So a written consent saying that they are agreeing would perhaps be a better idea.
Dr. Gulati,
but this is very valid. Legally, this is valid.
But Dr. Tushar, do we have to take permission from the patient when we're doing video recording?
Yes. At least you have to inform them, and if they don't object, then that is taken as consent. You don't have to ask them. You can say, "I'm doing video recording." Okay. So he doesn't say anything, or he says, "Okay, it's fine."
Sir, my question, sir. If a patient comes to me and I tell him that you are being recorded, there are number of cameras. I show them that there are approximately 24 cameras in my clinic and every sound and video is recorded. And अगर वो कहते हैं कि सर हमको रिकॉर्डिंग नहीं चाहिए तो मैं बोलता हूँ मैं आपका ट्रीटमेंट नहीं कर सकता हूँ और मैं पेशेंट को वापस भेजता हूँ मैं बोलता हूँ मैं नहीं करूंगा ट्रीटमेंट आप
That is your choice. That is your choice.
Yeah.
That is your choice. Dr. Punumbulati, your question, please.
Good morning, everybody, and thank you for giving me this opportunity. Now, I'd like clarification on some points regarding this thing, video recording. What is done in the hospitals nowadays is that for their legal purposes, they just put up a notice that you are under CCTV surveillance wherever they have these ICU briefing rooms. That is considered as that you have informed the patient enough, and then it is up to them. And the hospital records the statements of those patients whom they have been explaining. But Dr. Tushar, I want to ask regarding this procedures in the OPD, IND and all. Now, where does one record this thing? Because standalone clinics, how much paperwork, over 10, 20 years, they will have 2,000 incision and drainages done or small OPD procedures done. So where do they record all this thing and how much are they supposed to record, like 3 years, 5 years? But is it enough if we write it down, take the patient's consent on the prescription that we are giving him, that so that the patient keeps this thing and the onus lies on the patient to produce the consent or the lack of it from that day's prescription?
Okay. So 3-4 points here. One is you are under CCTV surveillance should be immediately removed. Nobody has given consent for them to be under CCTV surveillance.
Oh.
What is to be written is that this area is under CCTV surveillance. You see, you are surveying the area. You are not surveying you. So you should immediately remove because you say, I have not given you consent to survey me. Why are you surveilling me? You survey the area.
That is what is written usually. Yeah.
Okay. So that's one point. Second point you said is that regarding IND. Yes, every single IND has to have a written consent. There is no doubt about that, right? And whenever there is a written consent, all these points have to be written. All has to be covered. The 6 points, which Dr. Prem Agarwal has also highlighted. What are the advantages, disadvantages? What are the alternatives, etc. All this that is regarding this IND, so that those points are covered. And they have to be kept by the doctor, not by the patient, because you see, if it is not the onus of the patient to produce the record, because the doctor is saying that I have taken the consent. So in the Indian Evidence Act, whoever says that he has done something has to produce the document. So in this case, because the doctor is saying that I've taken the consent, patient is saying that no consent was taken. So the patient says, how can I bring the paper? Nothing was written. So that if nothing is written, nothing is there. What can I produce? So it is the doctor who is supposed to produce. So it is the doctor who must keep the record. And the period of keeping is 3 years, because that is the period of limitation. For example, a patient can bring an action against the doctor for some wrong that he perceived wrong, can be up to 3 years from the date of that perceived wrong. So the record has to be kept for at least 3 years.
The other thing is that for procedures like transplants, now there can be an n number of complications and n number of outcomes. Now the Supreme Court itself says that you do not have to explain in detail to the patient all the eventualities that can arise so as to put him off. That is what they have worded it. But you explain to them reasonably what may go wrong. So
exactly.
Who draws that line that whether a particular possibility was explained or not?
Yeah. So this is actually the problem with the informed consent. So the whole question comes to, they say material risk. The whole question comes as to how do you interpret material risk, right? So the Supreme Court has themselves said that you need to tell them what is reasonable, but don't have to go into some theoretical this thing. So there is this British Journal of Anesthesia article which qualifies this, that what is this. So what we generally follow is if it's a 1% risk, then you have to explain. Anything that is less than 1% risk, you may or may not explain. So that is the current situation. It may change with the next judgment, but that's the current situation. Up to 1% risk, you have to explain. Below that, generally not to explain. Generally, for practical purposes, we take a 0.1%, as that is 1 in 1,000 risk as a risk. We say that this is rarely possible, and we list those as rare possibilities.
Dr. Tushar,
so just one more point over here.
Yeah,
now,
please.
Regarding this openness and the latitude that a consent gives us, when you take up a patient for, as in your specialty, say for angiography, so how much is the validity of angiography and proceed? Whether immediately you may require at some patients may require angioplasty immediately, right? So whether
Yeah.
that
How long
angiography
will
and
it
proceed
take?
includes that, or
No, actually, and
normally
proceed.
all cardiologists would come out and explain there is a 70%, 80%, 20% block here, there. We'll need 2 stents for recent. But whether that is covered within the angiography and proceed, because in cardiology, everything can be justified as life-saving, life-threatening.
So the and proceed is not valid, because and proceed doesn't tell you what procedure is being done. So here the consent has to be procedure specific. That means what exactly is the procedure being done, that has to be written down clearly. So and proceed, in my opinion, has no legal validity. And as I just said, you have just quoted to me the Samira Kohli case, that coming out and explaining to others that this needs to be done, and the others agreeing to the procedure is absolutely invalid. Let me be very clear on this point. This is an absolutely invalid consent. Consent has to be taken from the patient. So the patient must understand. And I can legally argue that the patient who's undergoing a procedure is mentally befuddled and cannot analyze all these points before giving a valid consent.
कैंसर पेशेंट समटाइम द रिलेटिव से इनको बताइए नहीं, डिप्रेशन में चले जाएंगे और दे ब्लेम द अदर डॉक्टर कि उन्होंने बता दिया तब से इलाज नहीं करा रहे हैं. It's a very difficult situation. So how do you handle, and how does what does the code say about it?
I think that will, sorry to interrupt, I think that Dr. Tushar Rai is taking on next Sunday on communication. That will also be part of communication. Dr. Tushar, there is a question in cesarean section. Do names of anesthetic and pediatric doctors need to be mentioned?
Can pediatric?
In a case of cesarean section, will the anesthetic and pediatric doctors also need to be mentioned?
Yes, it is better to mention. It is better to mention both the anesthesia and the pediatrician.
Okay. And Dr. Sinha, your last question, please.
Sir, am I audible?
Yes, you are audible.
My simple question to Dr. Tushar, that once the patient comes to the clinic, he gives an implied consent. So it is acceptable in court of law. But during injection, suppose we want to give some injection. So many times there is a controversy. They say that it is implied consent by giving injection, but somewhere it says that you must take a consent. So there is little confusion between this for vaccination and other injections. Is it an implied consent or express consent has to be taken?
No, express consent has to be taken, but that express consent can be oral.
Oral.
It need not be a written consent. You can just ask the patient in front of witnesses, your staff and their relatives also, that I'm going to give you this vaccination. Is it all right? Generally, it's safe. कोई ऐसा कोई खास problem नहीं आता है. You can say that, because generally vaccines have very little problem. Their problem rate goes into less than 0.1%. So you can say that, and oral consent is very valid.
I think there is a question. Every broad dead patient has to be made a MLC.
Yes.
Yes. 99% doctors are not making videos. So what is validity of oral consent?
No, oral consent is, as I said, oral consent is very valid. In fact, as I am slightly against the video recording, because video recordings record everything, and a clever lawyer may turn around and point out that the X thing you're supposed to do, you did not do, and therefore the whole thing is invalid. So that can get you into trouble actually. So I would say that oral this thing, provided there are witnesses to that oral, is a good enough legal protection.
I think Dr. Chanchal, आपका वो जो cancer वाला question था, can it be answered in the communication next Sunday episode?
Yeah. We are anyway doing communication next. That can also, you can announce that one also.
I think in the absence of Dr. Kirti, I'll take up the onus of giving a vote of thanks. Dr. Tushar, once again, I must say it's a great effort. Those slides are just beautiful. And that's what your effort encourages us to carry on. And we shall carry on. And the next Sunday, 18th morning, will be a presentation by Dr. Tushar Rai on communication. Is that right, Dr. Tushar?
Communication and records.
Communication and records. And subsequently on 25th, we have already lined up a presentation by a Vice Chancellor of Cornell University on lifestyle medicine used in managing non-communicable diseases. And the next Sunday will be on all issues related to biomedical waste, the rules and the existing laws. So with these few words, I thank Dr. Chanchal and a special thanks to Dr. Deepika Chabra for supporting us and making these arrangements convenient. We just log on and everything is working. Thank you very much, Jagsonpal, and especially Deepika. Thank you very much.